The schools of Orange County generally segregated Mexican children in the larger districts. For nearly 2 generations, from 1911 to 1947, the school district practiced segregation in Westminster, Orange, El Modena, and Santa Ana in Orange County, California. The schools educated Mexican children by molding them into a source of labor for the lowest paid and most physically demanding productive tasks in the local economy. The promises of education and equality that underscored Americanization stood in contradiction to separate schools for the Mexican children, and Americanization only served to reinforce societal prejudice. It was legal to segregate Mexicans on the grounds of language, age, or regularity of attendance. Therefore, from a legal standpoint, the current practice of segregating Mexican children appeared fully supported by the law. School boards throughout the state operated on the assumption that segregating what were viewed as the underachieving Mexican American students was a good thing. In the small farming community of Westminster, Gonzalo and Felicitas Mendez fought the political power of Orange County. Like all migrant families, the Mendezes worked in several different places until they settled down in Orange County as agricultural workers. In the early 40s, they decided to lease a farm in nearby Westminster. This meant that their children would enroll in the Westminster School. On the first day of the 1944 school year, the 3 Mendez children were taken by their aunt to the nearest school, the Westminster Elementary School, to enroll them. However, the school denied admission to the Mendez children on the grounds of language deficiency, although their cousins, also Mexicans, were allowed to attend. The Mendez decided upon organizing a local group of parents to petition the board to desegregate the schools. The essence of the Mendez case revolved around the charge that segregation operated to deny or deprive equal protection of the laws to English and non-English-speaking Mexican children. That argument impressed the presiding judge, Paul J. McCormick, and on the 18th of February 1946, he issued an injunction prohibiting the segregation of Mexican children. The defendants raised the separate but equal doctrine, thereby obliging McCormick to address the Plessy doctrine, that is, separate did not imply inequality. Thus, rather than acting as a protection for the practice of segregation, the 14th Amendment served to repeal segregation. McCormick also contended that no evidence existed that showed segregation aided in the development of English proficiency. Shortly before the appellate ruling, the legislature of the state of California struck down the educational codes that legally required the segregation of Indian and Asian children. Thus, Mendez reverberated beyond the confines of Orange County. Segregation, if it continued to exist, would be de facto. The era of de jure segregation, however, had ended in California.
In 1952, Brown v. Board of Education was heard in front of the Supreme Court. Brown v. Board of Education consisted of 5 separate cases that was consolidated into one because they were all arguing the constitutionality of state-sponsored segregation in public schools. These 5 cases were Brown v. Board of Education Topeka, Brace v. Elliott, Davis v. Board of Education Prince County, Bowling v. Sharp, and Gebhardt v. Ethel. These plaintiffs appealed to the Supreme Court under the Equal Protection Clause of the 14th Amendment, feeling that since segregated schools made black students feel inferior to white students, it should not have been legally permissible. Brown v. Board of Education was reheard in 1953, and the original Chief Justice on the case had passed away, so they replaced him with Chief Justice Warren. On May 17, 1954, Chief Justice Warren ruled separate but equal as erroneous and unconstitutional. The plaintiff's defense team consisted of Thurgood Marshall, Virginia Attorney General T. Justin Moore, Virginia Attorney General J. Lindsey Alman, AUSA J. Lee Rankin, Robert Carter, Kansas Attorney General Paul Wilson, James Nabbert, Milton Corman, Lewis Redding, Jack Greenberg, and Delaware Attorney General H. Albert Young. On a national scale at this time, the country was still dealing with Napoleonic codes, which is how they determined your blackness in New Orleans. If you were half black or you looked black, you were considered black. And that is how you were determined to whether or not to receive special privileges or not, based on how black you were. We were also dealing with white flight. After they passed Brown v. Board of Education, the moment they allowed black students to enroll into predominantly white schools, they noticed that the white students were fleeing. The families were moving to other parts of the city and the state to get away from the fact that the Supreme Court ruled that segregation in school was erroneous. So we experienced a huge white flight. The percentages dropped completely, turning these schools that were once in good neighborhoods to the inner city schools that we have now. Native Americans were experiencing the same erroneous treatment at white boarding schools. The schools were now located, they went from being in suburban areas to what we now consider urban areas because they are predominantly full of minorities due to the white flight. The difference in de facto and de jure is relatively simple. De jure is what the law says has to happen, and de facto is what actually happens in practice. As time went on, we ran into problems such as the critical race theory, where these are theories that were believed that racism was normal and not apparent in the US. To combat that, they came up with critical legal studies, which was workshops that was centered around analyzing legal scholarship and legal precedents. We also faced the economic crisis in 2012 when our black president, Barack Obama, was elected. White voters immediately were upset because the unemployment rate skyrocketed, and the financial deficit of the U.S. skyrocketed as well. And they thought that it was because that we had a black president, when in all actuality, it had a lot to do with the amount of debt the U.S. was already in and the abilities of the president to overturn that debt in such a short period of time.
The attorney representing the plaintiff was Edward Steinman, and the plaintiff was Kenny Lau, his parents, and 1,800 other Chinese students. The people in the Supreme Court were these lovely old white people, white males. And they were suing Alan Nichols, who was the president of the school district in San Francisco. So on a national scale, basically anyone who wasn't a white Caucasian was facing racism, rampant racism on a national scale. The population of Chinese Asians mostly was the region of California, Hawaii, their area. As far as housing and zoning laws, they were both segregated. And this was both in de jure and de facto, because not only were laws pro-segregation at the time, for example, like the Chinese would come to America, they wouldn't know people, nobody spoke their language, understood their culture, their customs, so they wanted to live around people who did understand them. Same goes with the white people and black people. So it was partly a preference. Difference in schooling. So clearly the white Caucasians had better public schools. African Americans had schools, segregated schools that were set up for them, but the Chinese people did not have schools when they first came here. They were slowly set up, and there was this constant want and desire and battle to join the Caucasian public schools. Chinese students were not allowed to speak their own language. They were not allowed to be hired at schools to teach children who spoke Chinese. And the schools were mostly located in the urban areas of the cities, while Chinese people lived in the rural areas of the cities, so outside of town. Let's see. So how are the cases connected? So the cases basically, they were built off of each other. So first you have the Mendes versus Westminster case, and that one set the precedent for Brown versus Board of Education, and that one set the precedent for Lau versus Nichols. And all three of these cases were very important as far as desegregating schools legally and making sure students had equal education opportunities as much as possible. A contemporary issue, I personally think that even though public schools are mandated to have ESL classes, which they do, they can be made to be more efficient and effective, because I don't think they are right now. It doesn't make sense to put a bunch of kids in a class who don't speak English and expect them to learn English that way. I think it would be better to maybe have them partner up with students who do speak English. So then there's this passing of wisdom and knowledge. That might be a good idea. But basically the school system in America still has so much to work on. But these cases helped with such big issues at the time, things that we don't even like really think about as much today.